As we discussed in part 1 of this series, the Regal Act directed federal banking agencies to create an intra-agency appeals process. Today I'm going to talk about the Federal Reserve Board's intra-agency appeals process, including what supervisory determinations are appealable, the procedure for filing those appeals, and what you should do if you are considering challenging a supervisory determination. Not every decision by the Federal Reserve Board is appealable. And rather than define with precision exactly which decisions can be appealed, the Federal Reserve Board has come up with some examples of certain determinations that are considered appealable material supervisory determinations. Those include examination or inspection composite ratings, the adequacy of loan loss reserves, and significant loan classifications. In addition, the Federal Reserve Board has proposed certain revisions to the appeals guidelines, and under those proposed revisions, the appealable determinations would also include, but still not be limited to, material examination or inspection component ratings, the adequacy of capital, accounting interpretations, and Community Reinvestment Act, including component ratings and consumer compliance ratings. The Federal Reserve Board hasn't come up with an exhaustive list of decisions that it makes that are not appealable through the interagency appeals process. But it has said that whenever there's an independent right of appeal, you cannot appeal through the interagency appeals process. So, for example, this would include prompt corrective action directives that are issued pursuant to Section 38 of the Federal Deposit Insurance Act, actions to impose administrative enforcement actions under the FDI Act and the Bank Holdings Company Act, capital directives, and orders that are issued pursuant to applications under the BHC Act. The initial appeal of a determination by the Federal Reserve Board needs to be filed with the Secretary of the Reserve Bank. In addition, it can be filed with another appropriate Reserve Bank official where that's been designated. For example, in New York, the appeal should be filed with the officer in charge of financial institution supervision. The deadline is within 30 calendar days of receiving the written supervisory determination that's being appealed, and that deadline can be extended upon request by the appropriate Reserve Bank. The Federal Reserve Board has specified certain things that have to be included in every appeal. That includes a written description of all the facts and arguments that the institution wishes to present, the approval of the senior management personnel that are responsible for the bank's U.S. operations in the case of a U.S. agency or branch of a foreign bank. And once that's filed, a review panel that is selected by the Reserve Bank that is comprised of persons who didn't participate in the decision being appealed, who don't directly or indirectly report to the person who made that decision, and are qualified to review that decision, will then hear the appeal. The Federal Reserve Bank of New York generally includes staff on the review panel that are from the same functional area as that which generated the initial determination that is being appealed. In addition to filing a written appeal, the appealing institution may appear in person before the review panel to argue the appeal. In addition, the institution can present testimony and call witnesses with the consent of the review panel. The Federal Reserve Board in New York has an appeals policy that indicates that an appealing financial institution has the right to be represented by counsel, and that with the consent of the review panel, CPAs and expert consultants may attend and participate in the hearing. After the hearing or the submission of the appeal, the review panel will generally issue a written decision within 30 calendar days of the filing of the complete appeal. If an institution is dissatisfied with the decision of the review panel on the initial appeal, the institution can then appeal that decision to the Reserve Bank president. For U.S. agencies and branches of foreign banks, the approval of the senior management person that is responsible for U.S. operations is required. And the deadline is that this has to be filed within 30 calendar days from receipt of the review panel's decision. The Reserve Bank president will then issue a written decision within 30 calendar days of receipt of the complete appeal from the bank. Now, if the institution is dissatisfied with the decision of the Reserve Bank president on the second level appeal, the institution can then appeal that decision to the appropriate governor of the Federal Reserve Board. The appropriate governor will issue a written decision within 60 calendar days of receipt of that complete appeal. And finally, although the law is unsettled, it may be possible to appeal that decision of the appropriate governor to a federal court. So if the Federal Reserve Board made a determination about your financial institution, and you don't like it, and you're thinking about challenging it using an intra-agency appeal, what should you do? Well, first, you can watch the first video in the series, where I talk about some of the strategic implications of any intra-agency appeal. And the other steps you take will involve your lawyer, because this is really a legal process. You want to apply for permission to disclose confidential supervisory information to your counsel, if that's necessary for your appeal. And this can involve both reaching out to the Federal Reserve Board and sometimes also reaching out to your state regulator, such as the New York Department of Financial Services. And you should consider whether to request an extension of the deadline for filing your intra-agency appeal pending receiving authorization to share the confidential supervisory information. Because otherwise, the clock is ticking for filing your appeal, and your lawyer doesn't even have access to the underlying documents they need in order to prepare your appeal. You also want to consult with your counsel concerning whether the type of determination in question is even appealable. You also want to make sure that your counsel confirms that the procedure and the deadlines that were discussed in this video haven't changed since the video was recorded. The Federal Reserve Board's current appeals guidelines have been in place since 1995. But on February 28, 2018, the Federal Reserve requested comment on proposed changes to the appeals guidelines. And these changes are pretty significant. Some are positive for financial institutions, and some are negative. And almost a year and a half has passed, but the Federal Reserve has not yet published new final guidelines. And most importantly, because this is a fast-moving process with short deadlines and a convoluted procedure, it's important that you hire a law firm that is experienced in handling intra-agency appeals.